Oyez, oyez, oyez. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. Get ourselves put together up here. And we want to welcome you to the March 7th, 2025 setting of the 7th Court of Appeals, sitting in Harris County, Texas. And we want to thank the deputy for being here to provide us security. We appreciate you coming on down. I want to thank the attorneys also for being willing to come and present oral argument in Houston and being part of this continuing legal education project that we've got going. With that, we'll go on and call the docket. We have one case for this morning. I'll dispense with the discussion of our normal admonitions. Both counsels have been in front of our court many times, and you know the time periods allotted and such like that, even though 2025, of course. And we'll just go on and start it up. The case we have for this morning is 07-24-00203-CV, Angela Kate Whittenburg, Wang, and others versus John Burkhart, Whittenburg, and others. Appellants ready?
Yes, Your Honor. David Mullen and Flannery Nardone, my partner, on behalf of the plaintiff appellants.
Mr. Mullen, are you doing the entire argument? Are you splitting time and putting co-counsel under the bus?
No, I'm going to make the whole argument.
Thank you very much. And for the appellees?
John Smithy here on behalf of the appellees, and I'll obviously be making the entire argument.
Very good. And with that, Mr. Mullen, you have the floor. Let's make sure all this IT stuff works, you know. Whenever you're ready.
I'm ready, Your Honor. May it please the court.
Counsel.
Appellant's brief starts out with a reference to Dickens' Bleak House, suggesting to the court that this is a case of endless litigation to no purpose, moral equivalency, the litigation of ancient grievances, and benefits no one but attorneys. Indeed, if you read appellant's brief, appellee's brief, and I'm talking about appellee's brief, obviously, and if you read the appellee's brief, you would get the impression that the appellees, defendants below, did nothing wrong, and that the case, the plaintiff's suit is almost inexplicable. None of that is true about this case. But more importantly, none of that is material to the issues to be decided by this court on the appeal. We were denied justice in the trial court, and we are seeking justice here in a breach of contract case, which is a core duty of the justice system, is to enforce or provide remedies for breaches of contract. This is a case that was tried to the bench.
If I may, counsel, now the contract you're talking about is a settlement agreement.
Yes.
A settlement agreement with regard to a dispute involving property in New Mexico and Colorado, correct?
Well, the settlement agreement itself was settled 5 pieces of family litigation that were pending in the 47th court in Randall County. Okay. The ranch was part of the disputes that were going on, but it was not the only dispute. There were multiple disputes about borrowings, from the estates and various things like that went back and forth, and settled all of those claims. In other words, it brought about family peace, and the provision that we're looking at was designed to prevent any repetition of that kind of attorney fee expense. So,
Is there currently a lawsuit pending in New Mexico right now?
yes, there is a partition suit that is still pending in New Mexico, and there is one in Colorado that's basically been resolved by the commissioners, and there's one in New Mexico that is ongoing as to what the division of the land will be.
The part of the contract that you're saying is being breached, if I understand, says in the event that an agreement over the property is not reached by the parties understand that further petition proceedings may be filed in accordance with the partial settlement agreement. Is that the portion you're saying was breached?
Yes, it's the part that says in the event the partition suit's filed, then the parties agree that they will enter into a stipulation that will tell the court to appoint commissioners to partition the ranch in kind, and that a portion of the ranch called the middle place will be apportioned, will be amongst a part of the portion partitioned to the plaintiffs, the appellants here.
And maybe I've got the wrong information in front of me. I don't see anything regarding a stipulation. The only part I see is it says further partition proceedings may be filed. That seems to be permissive or instructive of what might happen, but it doesn't impose an obligation on anybody to do anything.
It incorporates language from a prior settlement agreement that we call the partial settlement agreement, the PSA,
Yep.
and in that document it specifies that the stipulation must be made that provides for a partition in kind and the middle place to go to the plaintiffs.
Okay.
So the basis of your recovery is on a breach of contract?
Yes.
And is there contractual language that speaks to recovery of attorney's fees?
No. There's no contractual language that creates any particular remedy. We're proceeding under our common law remedies for breach of contract.
And is there a claim for attorney's fees pending in the New Mexico litigation?
No. The New Mexico litigation is just about the partition of the land. Under New Mexico law, there's no right to obtain attorney's fees as of right in a partition suit. They can be awarded by the court as an equitable remedy in a partition suit in New Mexico. But remember, the contract here, this compromise settlement agreement, specifically states that all claims for breach of the agreement will be brought in Randall County. And so we started out with that in the very beginning of this case. That was the first issue, was where's the venue?
So we have the Randall County suit, which is a breach of contract action regarding a breach of the partition clause involving New Mexico property, and that suit's still pending. And the damages, you won on the cause of action, so to speak, in the Amarillo suit. Of course, they found a breach of contract, and there's no damages. Your argument is, and correct me if I'm wrong, the attorney's fees incurred to get the parties to the table, so to speak, to enforce, to agree or partition the property are the damages.
Right, and that's completed. I want to make that clear. That in May of 2023, the defendants finally stipulated to the appointment of commissioners,
Okay.
and and these are in the findings. I'm not going outside the record. It's to the appointment of commissioners and to a partition in kind. And that was in May in 23. The case had been pending since October of 21. During that period of 16 months, there was all these defenses were put up and all these arguments were made to basically not comply, that the trial court found totally breached their obligations to stipulate to a partition in kind.
there a likelihood that the litigation in New Mexico will be continuing?
Well,
Even though they have commissioners appointed, if there's a disagreement with regard to the commissioners' decision, is there a judicial avenue to take?
there is, well, I believe.
And where I'm leading is, if that is a potential, then will the damages for purposes of the Amarillo lawsuit include the attorney's fees incurred in order to get the commissioner's decision enforced?
Okay, first of all, this suit is only about the attorney's fees incurred up till the time that they stipulated.
Okay.
So that's complete. What happens over there now, I don't know what's going to happen tomorrow. If they do something else that breaches the agreement tomorrow or, last week, I don't know if there'll be any more disputes. But at this point, the case is pending in New Mexico. The judge over New Mexico, for whatever reason, has, I think there's some things pending in front of the judge over there, and for whatever reason, those things have been pending quite a while without action.
Your point is, though, that without regard to the pendency of the New Mexico lawsuit, the issues that closed your ability to obtain damages as attorney's fees or whatever closed at the time the stipulation was signed?
Yes, in this case, yes. In this case.
Let me ask you a related question. If your breach of contract suit had been filed in Randall County, like it was, and Judge Schaap had ruled in favor of Mr. Smithy's clients that there was not a breach, would they have been entitled to attorney's fees?
Well,
or is it only a position, is it a one-way street? It seems like you're saying that their attorney's fees are being awarded as damages. And if that's the case, then under those circumstances, Mr. Smithy's clients wouldn't have any ability to obtain fees because there was not anything in the agreement.
Well, they didn't file a counterclaim against us. So could they have filed a counterclaim that we had breached the agreement? If we had breached the agreement, I think they could have filed a counterclaim against us. And with respect to New Mexico, for instance, if they had wanted to stipulate and we didn't want to stipulate, if we refused to stipulate, they could have filed an action in Randall County and recovered the attorney's fees that we caused them to incur for that breach in accordance with Texas law.
The trial court had some findings of fact that said there were other unrelated reasons for the partition delays. Does that have any effect on whether you're entitled to damages or not? It seems like that might be also a related issue on whether damages should be awarded.
No, I mean, the trial court is just saying there were good reasons for the delay. And if the court wants to dig into the record, the good reason is that the estate of Roy Whittenburg, Daddy Roy, the grandfather of many of the parties here, was open from 1982 when he passed away until at the time of the compromise settlement agreement in 2014. And then for several years after that, two of my people I'm representing, James Whittenburg and Elizabeth Huckabee, got the estate wrapped up. And so during that entire period, there was some email that went back and forth about, well, when we get the estate wrapped up, we'll deal with the partition. So that's the issue.
Let's talk about, I guess, the crux of the issue here. Attorney's fees as damages. Opposing counsel, of course, argues that generally in the American rule, attorney's fees are not damages. And there may be a few exceptions when, and they cite the case where there's a fiduciary relationship breached, and in order to cover, or I would describe it as mitigating damages for a breach of fiduciary duty or something like that, then you incur fees which are part of damages. How are these really damages, in your view, if the fees are just related to a litigation that's pending in New Mexico?
Okay. All right. So that's the core of the appeal. If the court looks at Nally, Xerox, and the court's decision in Aiken Gump, in each of those cases, the court says the American rule bars recovery of attorney's fees unless they're provided for by contract or statute for the fees incurred in the case before the court. In other words, the attorney's fees that we're seeking for prosecuting this case, which the court found that number, those fees are not recoverable, would ordinarily not be recoverable except for the existence of Chapter 38, right? That's the extent of the American rule. Those three cases say that is the contours of the American rule. But attorney's fees that are damages for breach of contract, that are the subject of the suit, the claim in the suit. So, you know, Nolly's case is just the case of a lawyer suing for his fees that were incurred in doing work for the client. And so that claim is not barred by the American rule. But the court's very clear in Nolly. I mean, the language is so clear. The court looks at Chapter 41, talks about how, that applies to all causes of action, and talks about how compensatory damages are economic or non-economic damages, and that economic damages are a pecuniary or economic loss. The court looks there first, and then the court says, if the underlying suit concerns a claim for attorney's fees as an element of damages, as with Porter's claim for unpaid fees here, then those fees may properly be included in a judge or jury's compensatory damage award.
Those cases involve, say for a hypothetical for a minute, you and I have a contract and I breach a contract, and that forces you to go litigate with Chief Justice Quinn, that this attorney's fees that you have can be used as damages against me, right?
Yes.
We've got a different situation here because rather than having a third party, we've got the same parties litigating in one suit and the same parties litigating in the other suit. Doesn't that take this outside of the Nally situation?
Well, it does not, because there are multiple cases that award attorney's fees for wrongful conduct where the attorney's fees are between the same parties, which I've cited, CBIF and the Pizza Hut case and the DART, the Dallas Area Rapid Transit case, are all cases where that occurs. And I would also say, Your Honor, that we have to look at the general rule stated by the court. In other words, we need to take the court's words literally in the Aiken-Gump case and in the Xerox case and in the Nally case, that the American rule only extends to the fees in this case, and that if they are sought for fees that are incurred elsewhere, either in other litigation, as in, for instance, the MintVet case, or in the DART case where they're incurred in the grievance process, or in the Pizza Hut case where they're incurred in a receivership proceeding that was necessitated by the breach of contract by Ronak, those kinds of fees, those fees are recoverable as damages under the court is saying, under the same rules that you would have for damages in any other contract.
That seems to circumvent Chapter 38 as being a source for getting attorney's fees. If you and I could litigate in this case and neither of us included an attorney fee provision, we could simply bypass Chapter 38 by filing a separate lawsuit and saying, now I've got a separate lawsuit and now I'm claiming those fees as damages. What would be the distinction there?
Well, the distinction is that, first of all, if you try a case, if I try a case against you and I'm seeking recovery, let's just say for unpaid legal fees, and I sue you as a Nally, and it costs me $200,000 to litigate with you, but I don't go for recovery under Chapter 38. Well, that's res judicata. It's over. I mean, I don't get to go file another lawsuit for it. And so it's resolved. Now, it seems to me that the issue about Chapter 38 is the court has drawn in these three cases the boundaries of it, and that only relates to the the attorney's fees in this case. And so that's, to me, is the core. Once you're there and you have that and the decisions that the courts have made on this, the statements that our Supreme Court has made on these issues, and you look at Chapter 41, that we're entitled to recover these fees. I mean, the question's really simple. Can somebody enter into a compromise settlement agreement, receive $1.1 million, as found by the judge, get other good things in the settlement, and then completely, totally breach their obligations with respect to specific acts they were supposed to take in the partition suit in New Mexico? Everybody knew it was in New Mexico. The ranch was in New Mexico and Colorado. And breach that, increase our attorney's fees by 20 times what they would have been, according to the testimony in this case, as found by Judge Schaap. It was $216,000 increase in the fees, totally due to them breaching a contract, and can get away with it. I mean, that's basically where we are. And you ask the question, well, what about now? Well, I mean, if they based it on the ruling by the trial court, they can do whatever they want over there. And there's nothing we could do about it. So
I know your time is coming to an end. You can address this in your rebuttal, but the case you cite, CBIF Limited Partnerships, it has a quote in there that talks about the Supreme Court's recognition that attorney's fees unrelated to the ongoing litigation can be recovered as compensatory damages. And that's what you're relying on. How are the attorney's fees, and again, think about this during your time, but how are the attorney's fees incurred in the New Mexico lawsuit not related to ongoing litigation in New Mexico?
Well, it's unrelated to the prosecution or defense of the claim, which is the contours set by Nally, Xerox, and again, Aiken Gump on the American rule. That's what they're saying. That's my take on it, Your Honor. And I will respond to what counsel has to say.
Thank you, counsel.
Your Honor.
May it please the court,
Counsel.
counsel. I would like to focus, if I have time, on basically five points. The first thing that I want to correct my good friend, Mr. Mullen, on one thing, and that is he made the comment that they're not seeking attorney's fees in New Mexico. Well, they are. When they filed the New Mexico suit, one of the claims they made were for the attorney fees in that suit, and it was filed several years ago. It's at 7 Reporters Record Exhibit 106 in the record. And so they sued for attorney's fees. Now, in this case, and we pointed that out in our appellee's brief, and in their reply brief, they said, well, we didn't sue for attorney fees in New Mexico, which they did, but they said the reason we didn't is because the other side would have simply required that we change venue to Randall County. Well, it's been several years now. We've never said that. If they're going to sue for attorney fees, that ought to take place, well, for attorney fees in prosecuting the New Mexico action. If at all, that ought to occur in New Mexico, because the New Mexico court is the court that is most aware of the circumstances and the time that's been spent, what would be a reasonable and necessary time, and how necessary those fees were, because that court has seen firsthand, really, the whole situation. So the fees...
But let me ask you a question. I mean, you didn't file a cross appeal on the breach issue. Judge Schaap reached that issue in Randall County. Doesn't that bind our analysis as to what the remedy is for a breach?
Yeah, so you have a finding by Judge Schaap that there's a breach, and we haven't complained about that on appeal. And so, yeah, I think you're right on that. So the question is, what damages has the appellant incurred? And I'm using appellant.
He also found that they were reasonable and necessary. didn't he?
He did find, the trial court or Texas trial court did find the fees to be reasonable and necessary. And had they recovered actual damages other than fees, they could very likely have recovered attorney fees in prosecuting the case.
Let me ask you a question along those lines, because my understanding from your position is you've got to be able to recover something. Hypothetical, I go to my accountant, I need an extension on filing my taxes. And they fill out the document for me, they do what they're supposed to do, and then they forget to mail it. And so as a result, I spend $50,000 over the next 6 months fighting with the IRS, where I've got attorney's fees. And the IRS finally concedes that they're going to give me an exception this time and let me get around that. I've now suffered that in damages, arguably, in the form of attorney's fees, but I've not ever had to pay anything extra to the IRS. Am I out of luck?
There are some cases in Texas, and the Supreme Court's never ruled on this, but there are some cases that say if they are transactional fees that you engage in as a result of the other party's misconduct. But those cases make clear that that doesn't cover litigation costs, that it only would be a transactional fee.
We have as I understand, $216,000 in attorney's fees apparently related to the New Mexico debate. Are all those $216,000 just related to filing the lawsuit and prosecuting the lawsuit and getting some type of order or agreement to have everybody go to the commissioners for the partition, or are there transactional things that are happening before?
Well, I would say there's a combination of both that are involved there. You know, the partial settlement agreement where the language is found says that the parties, the actual wording says the parties stipulate that the court will appoint commissioners. Well, first of all, I don't think parties can stipulate that a court will do something. You can stipulate, or you can agree to stipulate to the court that you will do it, but you can't really agree that you can't stipulate that the court will do something. I can't bind this court. I can't go make an agreement that this court's going to rule a certain way or dismiss a case. I can
Not even sure we can stipulate about how we're going to rule. So.
I can ask the court to do that. So that's one of the.
Well, with regard to what you just said, answer my question. You said some of it is transactional and some of it is litigation.
Yes.
Does the record reflect what proportion is transactional versus litigation? And if it being transactional is the test for whether or not it's damages, can we carve out those and award them as damages in your view?
No, there really are there is no way to carve those out. And when I said transactional, I don't think the evidence shows if any were. I just am saying I suspect there could be. I don't know. And I'm not sure, I don't think the record reveals that at all. So I answered that a little too quickly. I don't know of any transactional fees involved in it.
And the record has attorney's fees affidavits with regard to the New Mexico litigation?
I think there was some testimony in the case about the New Mexico litigation.
I guess maybe I have
Actually,
a
it
question.
was all involved. I'm sorry, I didn't mean to interrupt.
No, please go ahead.
But it was all incurred by the lawyers in New Mexico in connection with the litigation, in filing the litigation, in prosecuting the litigation, in their view, to get to the petition.
And so I guess maybe that is what I was going to ask you about, is your argument is that asking the commissioners to make that decision would constitute litigation. It's not being filed in front of judges or an initiation of a lawsuit.
Well, no, the way it works is, I mean, it was required. Those are litigation fees because you're going to court to basically, the appointment of the commissioners is part of the litigation.
Assuming, of course, there was a finding of breach contract, they did not abide by the agreement regarding partition. Assuming before a lawsuit in New Mexico was filed, opposing counsel's firm was hired in order to try to work out something, try to get him to the table, so to speak, in front of the commissioner. Lawsuit hasn't been filed. Are those litigation fees, in your view, that would not be recoverable, or would they be recoverable because suit hasn't even been filed yet, and they're trying to discuss a breach of contract?
Well, I think they're litigation fees from the standpoint that if this had occurred in Texas and it was an alleged breach of contract, and someone alleged a breach of contract and had to hire a lawyer, I think that lawyer, in recovering attorney's fees, could recover a certain amount before suit was filed as attorney's fees under Chapter 38, because those were in connection with the breach of contract and with the litigation. So, in other words, if I were to breach a contract with you, and your lawyer called me and said, let's send a demand letter, and we talked and we negotiated, couldn't reach a settlement, and then your lawyer files suit, I think that lawyer probably could sue for you could sue me for the attorney's fees that your lawyer.
In your view, would those be damages, or would they just be
there'd just be attorney's fees under
costs and expenses and attorney's
cost,
fees?
yeah, under Chapter 38.
Okay.
If they were reasonably and necessarily incurred in the prosecution of your breach of contract action. So that's the first thing, is if these are going to be recovered, they should be recovered in New Mexico. And in fact, the suit is ongoing, seeking to recover attorney's fees, so you could very well, if this court were to award attorney's fees, we could very well have a double recovery of the same fees. And the second thing is that this would basically abrogate over a century of law, of Texas law. The American rule, as the court is well aware, we've discussed this morning, it has, there's two exceptions to the American, well, the American rule is unless you have a contract or a statute, you can't recover attorney fees. There's two exceptions to the American rule that have been recognized, really only one by the Texas Supreme Court, but lower courts have recognized another one. The one that's been recognized by the Supreme Court has been for attorney, in the cases of attorney malpractice, and that was the Aiken-Gump case that's been referred to, where if an attorney has committed malpractice, when the client sues the attorney, they can recover the fees they paid that attorney as damages. That's an exception. The other, as Justice Doss pointed out, was that there's an exception when a third party commits a tort and it requires the spending of attorney's fees. In that situation, then the courts have allowed recovery.
Quick question. The New Mexico suit's not over.
Right.
If we were to agree with the appellants, there is a commissioner's partition, and there's a dispute with regard to that decision. First of all, does the court have to approve the commissioner's decision?
My understanding, I know less about New Mexico law than I do about Texas law, but I will say that
you helped create Texas law. Come on.
We've been saying that for years about the legislature.
My understanding is that that the court would have to then approve the commissioner's award.
And if there was a dispute with regard to that, they said the commissioner's decision is unreasonable, there's going to be attorney's fees incurred with regard to that to get that finalized. So if we were to agree with the appellants, that would mean there's more damages incurred for the breach. So the amount of damages has yet to be finite, potentially, until the New Mexico suit is over. Would that be correct?
Yes. You would not know the amount of the attorney's fees that they incurred over there until the litigation's over.
So this would be a continuing issue of attorney's fees. They could sue again?
Well, we didn't think they could sue the first time.
Understand.
But
let's assume that they are right.
If the court were to say, yes, the suit, you can sue that, well, then, yes, we could see other suits in the future, I'm sure, if there were additional damages incurred that they, blamed on a breach one of the two prior agreements.
See, my understanding from what I thought Mr. Mullins said just a minute ago was that the breach was the failure to stipulate, and then once the stipulation was signed, that what the result of the New Mexico litigation is irrelevant because we were only talking about what it took to tee up the partition to begin with.
And that may be, to the stipulation. When, like I say, the agreement said the parties stipulate that the court will do this, will appoint the commissioners, and so I think. Is
that what Judge found the breach was the failure to stipulate?
I believe so. He found that. Because there were legal proceedings in New Mexico. It was a very complicated case because there were a lot of issues going on as far as how the partition would be done, and it was much more complicated than counsel painted it. It was there's a lot of land at stake, and the family's been fighting about this for years, and so there were a lot of issues about a lot of parties involved. So there were a lot of side issues, and so. Judge Schaap made the finding that there were a lot of things going on that were not necessarily anyone's fault that led to this New Mexico litigation, and so we raised some of those issues in New Mexico, and Judge Schaap found that was a breach of our agreement just to go straight to the commissioners over there.
Can I ask you a question? I gave you kind of a hypothetical a while ago about going to an accounting firm to get a tax extension, and I believe your explanation to the chief just a minute ago was that pertains in situations where somebody has committed a tort.
Yes.
Let's say I have a contract with my firm that they're going to do these services and mail it out, and they don't do it. Does that change my remedy under those circumstances, where if I didn't have a contract, I could get it in tort, but if I do have a contract, I'm out of luck?
Well, I'm not sure that it does in that situation. I don't know that, and I don't know of any cases that would answer that question. But once again, those were transactional fees, and there have been some lower court decisions that have said transactional fees are recoverable, but they've also said in the same sentence, litigation fees are not. And so
I had to go litigate in the U.S. tax court over whether I had a timely extension, that those would not be covered. But my internal fightings with the IRS would be?
That would be, litigation fees against another party.
Okay.
And so I think that you could certainly make that argument. I don't know of a case along those lines, but I think that because the litigation is with another party, then you could possibly, that would present a different fact situation than what we have in this case.
Mr. Mullins' brief cites to CBIF and Pizza Hut and DART. Two of those are out of the Fifth Court, and then one of those is out of the Eastern District of Texas. Is it your argument that we should ignore those holdings? What's your position on that? And I think those all involve maybe person-to-person transactions and not a third party.
Yeah, I believe,
if I may, the CBIF case talks about attorney's fees unrelated to ongoing litigation.
Yep.
I guess in answering Justice Doss' question, can you also answer what do they mean ongoing litigation? Would that have been the Amarillo-Randall County case, or is that any litigation?
Well, I'm not sure about that. I know in the Pizza Hut case, my recollection of that case is there was an indemnity agreement in that case, and that specifically provided for attorney fees. Several of these cases that they've cited were cases where there was a specific provision in the contract that said, in the event of a breach, you can recover costs, including attorney's fees. And certainly that was one remedy here would have been when they entered into these agreements, the PSA and the CSA, parties are free to contract however they wish. They could have easily put a provision in the contract that said the prevailing party in any breach of contract litigation or any partition litigation can recover their attorney fees. That's what is generally done, and that's what could and probably should have been done in this case. And if that had been the case, we wouldn't be here today, likely, even arguing about this. And the other thing, Justice Doss pointed out a moment ago, is that if the court were to adopt their position, Chapter 38, specifically 38.001B8 would be totally unnecessary. It would be a useless statute, because any time that I could come in and allege and prove breach of contract, I could recover attorney fees. And so by doing that, the court is essentially creating a new cause of action judicially that the legislature has chosen not to create. The legislature put certain conditions on a Chapter 38 recovery.
I'm wondering if the fact that part of this litigation, or part of the suits are in New Mexico is important, because 38.1 would pertain to litigation occurring in Texas.
Right.
Correct? In fact, that's what I'm assuming they're invoking in order to recover the $500,000 in attorney's fees.
Yes.
So, but would 38.1 have any effect in New Mexico?
I think that...
Can you take your argument and say it will vitiate 38.1 if what they're trying to do is get attorney's fees incurred in New Mexico, in litigation in New Mexico?
Well, I'm not sure it matters which state it's incurred in. I mean, it was incurred in another case. And so if you say that you can, between the same parties, you've got identity of parties in both suits, and if you say, well, you can have one litigation going in one jurisdiction and then another one just for your attorney's fees in that other jurisdiction, that would lead to a multiplicity of suits. It would be terrible public policy to hold that way. And so it gets us back to, if there are fees that should be paid with regard to the New Mexico litigation, they should be considered and awarded by the New Mexico court, not the Texas court. It just leads to an unnecessary multiplicity of the lawsuits involved.
Again, going back to CBIF, I know your time's almost up, but it talks about Supreme Court's recognition that attorney's fees unrelated to ongoing litigation can be recovered. Is the ongoing litigation here all litigation, or is it the litigation that was filed in Randall County?
I think it involves all litigation between these parties that's going on at that time. And is the CBF case the same as Pizza Hut? Is that?
No, this is TGIF Fridays.
Oh, in Dallas, yeah.
Another restaurant.
That was out of the fifth court. And one thing I might say on that is there was a prior decision out of the Dallas court that said that there's only 2 exceptions to the American rule. And then they went in and said, well, it's not so limited, but they didn't really specify what it was. But then the Supreme Court just recently, in last term, went back and cited the prior case for the proposition that Texas still holds to the 2 exceptions of the American rule.
Counsel, your time's expired. We appreciate your comments, and
thank you, Your Honor.
I'll turn it over. Thank you.
Well, Your Honor, I'll try to be brief. First of all, many of the things they're arguing were not, they did not attack on appeal the court's findings of fact, none of them. And so, and the argument about, well, it should have been in New Mexico, that was made in their pleadings, and it was made by motion, and the court denied it, and there was no raising of that in this appeal as a separate error of the court. So that's all decided. That's not an issue. That, oh, you could have gone in over there, or was it I remember they called it an election of remedies. That's not in the case on appeal. The findings are in findings 24 through 27 that pertain to this specific issue, the breach of the partition in kind. The court found that it was a failure to comply with the partition in kind requirement, and that it caused the $216,000 in damages. There was an increase in the fees. There was no objection to the sufficiency of the evidence. There were 2 attorneys that testified to the increase in the attorney's fees. The court adopted the testimony of those 2 witnesses on the fees. In the Xerox case, the court says that the prosecution or defense in the suit, those attorney's fees are not damages in this suit. But the attorney's fees that are the subject matter of the litigation are damages. That's the Supreme Court saying that. And in the Seeley case that he cites about the Raz group, he takes the exact same position as CBIF does in saying that those were just examples of ways you could recover actual damages, attorney's fees as actual damages. They're not an exclusive list. That's what CBIF said, and the Sealy Court, when it says CEG, that means, from the Blue Book, C for example, right? Okay, so it's the same thing. I would point out to the court that in the they didn't attack the causation issue, the argument that they can't stipulate to something that the court has to follow. That was not raised in this appeal as an error by Judge Schaap. Judge Schaap said it was caused, and they didn't say Judge Schaap was wrong on saying it was caused. Our suit had to be filed in Texas for breach of contract. The contract says that, those very words. They raised the issue that we should be over New Mexico, that the case should be abated. It was denied. It was Judge Board who actually made that decision before Judge Schaap got involved. But nobody has brought that up on appeal that Judge Board erred. So those are things that were already resolved by Judge Schaap against their position, and they don't have grounds for raising it.
Let me propose an idea on where we are on whether it's transactional claims or it's claims against a third party versus the two contracting parties. Wouldn't it be an easier, more manageable rule and not run afoul of Chapter 38 if what we said was, look, when you and I are contracting with each other, if there's damages flowing from a breach that you have to resolve with somebody else, that's something you may not anticipate, so we're going to allow you to cover attorney's fees as damages there. But when it's a contract between you and I, we certainly can anticipate there's going to be a breach. We're going to require the parties to include an attorney fee provision in the contract.
If we had included an attorney's fee provision in the contract, which we didn't need to do because of Chapter 38, because we were going to be in Texas, the contract required us to be in Texas, it wouldn't have covered, it wouldn't have addressed, it would have been a rare provision that would have addressed, and if you breach over in New Mexico, then we also get attorney's fees. We're not required to do that. We have the common law, and we had common law rights, which I believe that Nally and Xerox and Aiken Gump recognize and clearly define. And our claim is for damages that were approximately caused by a breach of the contract. And I think our case is even stronger. Like in your tax idea, if I had a contract with you and you said, well, I'll file your return by April 15th, and then you didn't do it, I mean, certainly my position would be stronger than if I didn't even have a contract. So, thank you, Your Honors. Any other questions? Thank you.
Thank you, counsel.
And thank you for having Mr. Smithy and I come and argue this for you in this great setting.
Again, thank you for coming here. Mr. Smithy, just a comment. You said that you wanted to cover 5 topics, and I think we asked a lot of questions. I don't know if you covered your 5 topics, but you
reminded me what my 5 were.
Okay. But you realize that when you're up there and you're getting asked questions, time goes by awfully fast, don't you?
Well, I'm throwing my outline away, too. I don't even remember what.
And, of course, as you know, we play devil's advocate quite often up here. Just our comments do not read into them our ultimate decision. As I said, sometimes we can't stipulate what we're going to decide, too. So you'll see our decision when you get the opinion. We, again, appreciate you journeying to Houston and being presenting your argument here and being part of this continuing education project. And I want to thank Mr. Baruch, wherever he is, for giving us the opportunity to do this. And with that, the case is submitted, and you are free to leave or stay, and we will be in recess.
I think we should applaud the attorneys for their effort.